Good morning and welcome to this side event on the role of the IP system and in the adoption and diffusion of climate technologies. We have a distinguished panel here this morning that will discuss a range of views on how to incentivize innovation, encourage the promotion and adoption of climate-friendly technologies, and address the role of intellectual property. For those of you who were in an earlier session, and I think most of you have been here since the earlier session, will have had the discussions earlier that addressed a lot of intellectual property in general. The discussion this morning will also examine the range of options put forward at the UNFCCC negotiations, both in economic and legal terms, including measures that relate to intellectual property. As our colleagues at the ICTSD recently reminded us that in 2011 marks 50 years since the question of intellectual property and technology transfer was first debated in the UN. In 1961, as you all remember, in the Brazilian-sponsored initiative, the role that intellectual property, particularly patents, can play in the transfer of technology to developing countries was first identified as a matter of concern to the UN. Since 1961, a great deal has changed, but in many ways, the international community has yet to come up with answers to some pretty fundamental questions, which are, for instance, what best practices are there on promoting technology transfer to developing and least developed countries? What are the most effective incentives to encourage technology transfer? And most relevant to today's discussion, what could be done to settle the role that intellectual property can play and overcome this impasse to best encourage research and development? And indeed, some of those topics were addressed in the earlier session. This expert panel will shed some light on some of these issues. And before turning to the distinguished panelists, let me just say a few words about some of the initiatives that WIPO, the organization I work for, which is a UN specialized agency responsible for intellectual property, is attempting to do on a practical level. In our work, we try to address a number of different points in the innovation chain. The first is the policy environment. WIPO's development agenda, which was agreed by member states in 2007, identifies quite a few ways to promote both technical assistance and technology transfer. In particular, WIPO member states agreed to explore intellectual property-related policies to promote technology transfer to developing countries and to take steps to enable developing countries to benefit from flexibilities in international agreements. A number of things have flowed from this, and as recently as last month, member states agreed to establish a series of regional workshops to bring together experts and policymakers to share experiences and discuss case studies. This complements a number of the projects already in place at WIPO. The second point WIPO is looking at is the innovation in the innovation chain that we try to target is the research phase. The global technology databases that WIPO manages are a great resource for innovators and entrepreneurs. As Ahmed said in an earlier session, searching for patents is an absolute nightmare. It is not easy at all because of the nature of most of the green technologies. So WIPO is attempting to address that and has developed several databases to try and ease this burden. We have a range of databases ranging from a network of technology innovation support centers in developing and least developed countries to enable innovators and entrepreneurs to take advantage of this. We have a database called IPC, Intellectual Property Classification System for Technologies, for Green Technologies, and several others. The third point in the innovation chain that WIPO is seeking to work on is the issue of the diffusion phase. As you know, imperfect information can lead to market failure. Those needing technology may not be searching in the right places, and those with available technologies may not be aware of the variety of possible markets out there. That is why we're in the process of creating a new tool to improve diffusion on climate change technologies. WIPO is developing a new initiative called WIPO Green, the Sustainable Technology Marketplace, which will have three elements. First, a global comprehensive database where technology providers are committed not only to licensing their technologies, but also to making available associated information and know-how that facilitates real-world deployment. Secondly, a partnership hub will be created, which will be a neutral intermediary to facilitate building partnerships necessary for successful deployment. And the third area will be a supporting service that WIPO is hoping to provide on training, consulting, guidance on finance, dispute resolutions, et cetera, et cetera. The environmental factors that we know help to facilitate tech transfer. With those introductory words, let me turn to my panel. We have had some changes. Gabriel, his name is still there, but we know that he's very, very involved with the tech mechanism, and the chances of him being here are very slim, so we understand that part. But maybe I'll start on my extreme left. I'll start with Jake. Sure. Jake Colvin, your association, the National Foreign Trade Council. You have a variety of innovative experiences when it comes to diffusion of climate change technologies in the developing world. From your perspective, what are some of the factors that in practice can really help to facilitate that? And if you could also address the role of the intellectual property system in seeking to invest and develop these technologies.
Sure, well, and thank you, Kanji. I appreciate the opportunity to be here, and thank you to ICTSD as well. Let me say first that I'm liberated by the fact that I'm not an attorney or an expert on intellectual property rights. I work for an association, the National Foreign Trade Council. We're based in There we go. So we're an association. We're based in Washington, D.C. Our members are large, mainly U.S.-based multinational companies, and so we have a number of members that you would think of in the traditional climate change space, including General Electric, Siemens USA, United Technologies. But then there are a number of other diversified companies that do work in the climate space. ExxonMobil is a leader in CCS technologies. Procter & Gamble recently doubled their 2012 emissions targets and has opened up a solar-powered facility in California. Walmart is in the process of greening its supply chain in China and around the world. And so I feel like I have a pretty unique perch from which to see how our companies interact with clean technologies and with the IP system, including in forums such as the WTO, APEC, and here at the UNFCCC. So when I look at how our member companies decide about how they develop products and how they innovate, they tend to gravitate towards places that have strong legal systems, favorable tax regimes, good regulatory environments, and smart people. And to me, it's those investments and the advances in research that can be done on the ground, particularly from the private sector, that enable countries to develop and access new technologies. And so for me, it's much more about innovating and then attracting and deploying technologies, even than, say, describing it as technology diffusion. For me, diffusion suggests some sort of a passivity that if you sort of sprinkle technologies around, then you're going to solve the climate puzzle, and I don't think that's the case. And so what it is these days, I think, is competing around the world to attract technology and research and trade and investments. You know, the world is increasingly flat these days, and so companies can invest wherever they want around the world. And they tend to decide where to go, like I said, to places that have good regulatory and tax regimes, good public policies, and good infrastructure. So one of the things that I've had the opportunity to do over the past couple of years is, thanks actually to a grant from the General Electric Foundation, is my organization has set up a series of forums around the United States. Places like Research Triangle Park, North Carolina, Detroit, Michigan, Cincinnati, Ohio, and Silicon Valley in California. And we gathered a group of large companies, small business CEOs, and educators. to talk about problems that they have accessing international markets and challenges that they have innovating across borders. And so I wanted to share with you maybe a couple of lessons that we learned which touches on the IP issue. First of all, it would come as no surprise that companies like favorable tax regimes and tax incentives, and that's certainly something that came up over and over again. What surprised us a little bit is how often what sort of called people policies came up. The ability to hire and move around highly educated and motivated talent. This global mobility is actually a huge issue in the United States because it hampers us from bringing folks from other countries to the United States to live and work. Physical infrastructure kept coming up as important, being able to get your goods around the country and then in and out of the country. But the one thing that came up again and again was this idea of a fair and predictable legal environment, and particularly strong protections for intellectual property rights. I mean, companies say again and again they're simply not going to invest or make technologies available in countries that lack adequate protections for IP. This was a particular issue for small business CEOs, and we had a number of them who felt very strongly and took this personally. Some of these people spend a shockingly large amount of time trying to figure out if their technology is going to be stolen in overseas markets. They spend a lot of time trying to figure out whether or not they can trust their overseas partner where there is a proposal to do business. And then they spend a lot of time overseas trying to convince customers that knockoffs of their products are not actually theirs, and it broke because it was of inferior quality, and they shouldn't be blamed for that. And so IP is a huge deal for companies when they seek to invest overseas. So given all that, and when you look at the UNFCCC process, I feel like there's a bit of a disconnect, and it's surprising to me that the effective protection of intellectual property rights is considered a barrier in any way, shape, or form. I think most of the first panel talked about how IP is essentially not a barrier, and there have been studies by the U.S. International Trade Commission, the EU, and the OECD, which show a correlation between intellectual property protection and technology flow. And I think, in addition, if you look at it, when I listen to how our member companies operate around the world, sort of suggesting that IP is a barrier misunderstands the role of the IP system, which I think is about building trust and making clear that there's a predictable and workable operating environment for companies to work in overseas. Actually, Thaddeus mentioned this already in the previous panel, but one of the best experiences I had in Copenhagen was with one of Thaddeus's colleagues at GE, where he described the joint venture that GE has in the wind sector in China. And there was a great sense of enthusiasm there and a great sense of a win-win from both sides. And he went into a lot of detail about how important the IP system was to enable the trust that allowed the two companies to operate successfully. And so that's the sort of thing that I think is useful to socialize at forums here like the UNFCCC and in forums like APEC and the WTO. There are a number of ways to address these challenges. I mean, public policies are important in making sure there's a predictable legal environment for IP and for other things. In the United States, we have our own challenges, and so some of the issues that I just mentioned, we've got proposals that we would like to see adopted in Congress that would, help encourage global mobility, that would make more secure and predictable investments in basic R&D, provide for a long-term extension of R&D tax credits. And then on the trade side, we're strongly supportive of efforts to effectively enforce intellectual property rights globally and to develop things like an environmental goods and services agreement that would lower trade barriers to clean technologies. And this is not to suggest that all countries are equal and that we should that developing countries are the same. And certainly there are areas that we need to see progress. I think Ahmed mentioned a number of them this morning. Certainly I think we're in favor of technical assistance and collaboration and financing, although that is increasingly challenging in the United States context. Trade facilitation is a huge challenge, and we would like to see progress there in the WTO in particular on an agreement that would facilitate trade. And then we're continue to pay attention to the UNFCCC technology and financing mechanisms because we think that they could potentially play a useful role in sort of sharing knowledge and collaboration on technologies. Maybe I'll end by saying I do think that we inhibit progress in forums like the UNFCCC if countries continue to suggest that intellectual property rights is a barrier, because that puts a brake on all of the other good things that we could be doing on the technology mechanism, financing, and the rest of the negotiations. I mean, we hear often of red lines for the United States and for a number of other countries on IP. And to the extent that these, I think, unhelpful proposals on IP continue to manifest themselves here in the COPs, we endanger the rest of the agenda. And so maybe I'll just leave it at that. And thank you again, Kaji.
Thank you. Thanks, Jay. Ahmed, I think I'll turn to you. ICTSD has just produced a publication, an excellent publication. If I may ask you, what do you think needs to be done to overcome the impasse on intellectual property and climate change? What should and could be the way forward to ensure that the issue of IP does not disrupt the UNFCCC negotiations, being a moot point, I think, right now?
Thank you. Thank you very much, Kanji. Thank you for the invitation. It's a pleasure to be here. As you referred, we are very much frustrated also about the way the intellectual property issues has been discussed in the context of the climate change negotiations. And we are at an impasse in the sense that the issue is haunting us there. It comes back constantly, but it is not discussed. And we also feel that as long as this continues to occur, it can have a disruptive effect on other progress that is made in the climate negotiations. So we think it is time to move away from this impasse. And so we just released a publication that tries to suggest maybe a path forward on how to move. Why are we at this impasse? There are different considerations. We cannot exclude that some countries see intellectual property as part of a bigger bargain, and it's a chip in a bigger bargain, maybe. That is something we as in the policy community cannot do much about, but to follow this. But the other aspect in terms of the policy debate is that this impasse is also related to the way the debate has been framed. And it is dominated, it has come to be dominated by two very uncompromising views on the matter. One view A, I would call it, that says IP is essential to clean energy innovation and can only be a facilitator of technology transfer and diffusion. View B, on the other extreme, says IP is inherently a barrier to transfer of climate technology to developing countries, and we need to take measures to remove such barriers. A very black and white view of the world that we think does not correspond to reality with the co-authors of this note. And we think the world is gray in many of these policy debates, and we need to move to this gray area of the world and to leave this two black and white positions. Of course, I'm not trying to, not pay enough attention to where are these positions coming from. I think there are valid policy concerns behind them. I think there is apprehensions that if you open a Pandora's box on this issue, you don't know where you're going to end. And on the other side, you also have concerns about the fact, well, if we're discussing this issue of technology transfer for many years, for a long time, the issue of intellectual property has come out and it's part of the discussion. So why shouldn't we discuss it? So through these publications, we try to do three things. We try to untangle the issues a bit behind this impasse, to clarify the debate. And we say it is unlikely that immediately, at least, we will agree on the substance. Okay? But at least let's try to agree on how to discuss it. Let's try to agree on a number of principles and parameters that can guide the discussion and can give a bit of reassurance and safeguards to all the points of view that are involved, right? And ultimately, we think that this could be achieved by trying to find a middle ground between these two extreme positions. And I was very gratified yesterday to hear that the chair of the Technology Executive Committee, Gabriel Branco, who should have been with us, he was saying the same thing. We need on IPRs to reach a middle ground, right? Between these very two different views. This middle ground, in our view, needs to acknowledge that intellectual property has a dual role. A dual role as an incentive to innovation that needs to be recognized, highlighted, encouraged, protected, enforced, you name it. And it also has a role in technology transfer and dissemination. And this duality is very well captured in what is the international consensus in intellectual property, which is the TRIPS agreement. The TRIPS agreement tells us that intellectual property should contribute to the promotion of technological innovation and to the transfer and dissemination of technology, to the mutual advantage of producers and users, in a manner conducive to social economic welfare and to a balance of rights and obligation, right? So these two aspects are embedded there, right? And what often happens in this discussion at the UNFCCC that we confuse these two aspects, right? We talk about the role of intellectual property innovation that we think should not be disputed, and we also talk about the role of intellectual property in technology diffusion and dissemination. And that the role of intellectual property in this area is not easy to grasp, is not easy to pinpoint, is not easy to isolate it. It's not easy to isolate the role of intellectual property in technology diffusion compared to other institutional issues, market issues, economic issues, absorptive capacities, etc. We go very quickly in this publication through the available empirical evidence because we think the available empirical evidence should inform this debate. I will go very quickly through it. We have patent landscape reports that are available now. We have licensing surveys that we have done on ICTSD. We have a number of country-specific, sector-specific studies. And I think the evidence is not very surprising in what you could expect. The patenting is dominated by industrialized countries, but that is the case of most technologies, so it's not that new. There has been an increase in patenting of clean energy technologies, but again, that is also reflects global trends in patenting. That is nothing, again, very surprising about this. The licensing surveys, I think, show some interesting results in terms of, and I have already mentioned them, about, I think, an unfulfilled potential of licensing to developing countries. And it's very difficult to deal with licensing as an issue because it's done by companies, it's very difficult to address, but I think the two lessons we have come out of this available empirical evidence is that we assume that the information is out there on what is protected by IPRs and what is not, but it's not the case. There needs to be an effort that is led by a number of agencies, including WIPO, to try to present this information in an accessible manner to policymakers. And the other issue is that technology licensing to middle-income countries, of course, is an issue that requires special attention. I think it has been mentioned in the previous panel. There's not, at least the evidence shows that there's not many patents in low-income countries on these technologies. There's often, and these countries are exempted of IP protection under the TRIPS agreement under the transitional periods. So it's not much an issue there in terms of low-income countries. We have done our part of this exercise on empirical evidence, and we base a bit our thinking in this area about our joint work with EPO that led to this patent landscape, the licensing survey, and this new patent classification on clean energy technologies that I spoke previously. And as I mentioned, the licensing results of this work shows that, again, the majority of respondents to our licensing survey said they had never licensed their technology to a developing country, right? But I think it reflects that globally licensing in this area goes mostly between industrialized countries, or it goes to a certain number of emerging economies such as China, India, and Brazil, South Africa. So one part of advancing in this discussion is that there's too many options on the table. There's too many options. And it's time to narrow down the options. And there are some of these options that would entail changes to international IP rules, right? Changes to the TRIPS agreement. Among those proposals that say that we should exclude climate change technologies from patent protection in developing countries and least developed countries, okay? We say in this that it's time to take these options out of the table because, as it has been said, there's very few patents on these technologies in low-income countries. They have transitional periods on the TRIPS agreement, and the evidence doesn't show that this is needed for the moment, okay? And it pollutes the debate, it pollutes the discussion, and it leaves it, it creates controversy, and it doesn't help the discussion advance. So let's take this out. Okay, so next stage, we say, let's look at options within the existing international system, within existing international rules. I think everybody should be happy with that, right? The existing international rules include rights, obligations, and they include flexibilities. So again, we're saying, if under current international rules, what could be the principles and parameters for a balanced discussion, a middle ground discussion? 2 procedural parameters that we should try to inform discussions by empirical evidence as much as possible, and that the outcome of the discussion should not be prejudged in advance, right? We should not try to in advance say, well, we want the result to be this. In terms of the principle, I think it captures what I've said before. We need to recognize, acknowledge the role of IP as an incentive for the private sector to innovate in clean energy technologies, no doubt about that, and that any discussion should balance and take into consideration these two aspects. But we should also not shy away that if there is a case where IP could be a barrier, a specific case, it should also be recognized, right? As a result of the cost of licensing, as a result of licensing practices, as a result of refusal to license, these practices exist, right? Again, they are recognized by the TRIPS agreement. The TRIPS agreement talks about the possibility that in some cases, IPR practices can adversely affect international transfer of technology. It is an established principle. And finally, the 2 other principles would be to call for more empirical evidence by country, by sector, and to consider all options within existing international instruments, again, which contain rights, obligations, and flexibilities. Finally, to conclude about how to reach this middle ground, we think it's very important to adopt an incremental and gradual approach to the discussion. I think it's useless to start this discussion with compulsory licensing. People who start this discussion with compulsory licensing, I think, do not want the discussion to happen, right? Because we are going really to the most controversial issue in the whole options that are out there. So let's take an incremental approach, a gradual approach, and start by discussing, I would say, technical and non-controversial issues. For example, the availability of information regarding climate technologies, and the exercise we went through with the European Patent Office showed that it's not a given. You need to think about it. You need to work with it. You need to work on it. Issues about technologies that are in the public domain, again, it's not easy to identify them. Patent offices in developed countries, in the US, have taken something called fast tracking of green applications, of green patent applications, right? So they try to fast track applications relating to green technologies. I mean, that's a fascinating issue. I mean, a very interesting measure. I think that it should be also discussed. Maybe other countries can see how this is done, how it is implemented. Again, I think, and this is a measure to encourage innovation in this area, to encourage innovators, right? And the issue of more favorable licensing terms of climate technologies to developing countries, particularly from publicly funded research. And it relates to what I was saying, that there's a lot of research in clean energy technologies that is done by public institutions. And encouraging licensing, again, there's a variety of things. There's capacity building, there's encouraging that developing countries, for example, are more aware of how do you negotiate a technology licensing agreement, etc. and then move then on at the second stage maybe to other options that are out there, such as open innovation, maybe patent pools, and the use of flexibilities in international instruments, the issue of pooled procurement strategies, etc. Again, any discussion in the UNFCCC will not change international rules on IP at the WTO or elsewhere, right? So it is not useful to engage such discussion in the UNFCCC, right? So again, the discussion here should be about how to address concrete cases that countries might face in this area, based on the results of studies, of experiences, etc., if needs arises, right? But just to finish and to conclude, to say that, again, we think that as long as the issue is not discussed, it will remain the elephant in the room. And many of the countries who claim that IP is a barrier, if you did a patent landscape in these countries, you would find, again, very few patents on clean technologies in these countries, right? But again, as long as we don't discuss it and we don't open an evidence-based balanced discussion on this, it will continue to feed speculations, misinformation, etc. So again, that's I mean, we've tried to do a small effort, a small contribution to the policy debate, because we saw that we think it was not advancing, it's not moving. But again, this is a product that other could use part of it, some of it, and for the creative discussion among stakeholders in the UNFCCC, etc., just to try a bit to move a discussion to a more, let's say, to a more constructive stage. Thank you very much.
Thanks, Ahmed. Our next speaker will be Thaddeus Burns. Thaddeus, you're the Senior Counsel for Intellectual Property and Technology Policy at General Electric. I guess we can agree that IP can have an incentivizing effect for R&D, as you heard. But I wonder if you can tell us how General Electric views some of the other aspects of intellectual property. In particular, how does General Electric view the role of intellectual property in the widespread adoption, and diffusion of relevant technologies, relevant green technologies in the developing world?
Well, thank you very much, Kanji. And you always have to ask the tough question. Maybe just a little bit about GE and what we do and our commitment to what we call eco-imagination, and then I will try to answer your question and also to respond to some of the issues that Ahmed has raised. You know, GE is a company that's been around since the end of the 19th century, and ever since Thomas Edison started filing the first patents for the General Electric company, we've been a company that focuses on innovation. And our tendency has been to move into sectors just as they're moving into that sweet spot in terms of moving up the technology value chain. And then once they move into commodity space, most likely get out of that sector. So a couple years ago, we moved out of plastics. You know, in the 50s, plastics was the place to be. Most plastics technologies today are fairly commoditized, and so we don't see that our R&D capacity can add a whole lot of value in that area anymore. Where we do work today, and we're a pretty diversified company, obviously in the area of power generation throughout the value chain, wind turbines, solar, your more traditional technologies like gas turbines, and nuclear as well. In the aviation area, jet engines, as well as the avionics that optimize the functioning of an aircraft and can make it more efficient. In the medical space, medical technology, diagnostics, and still in lighting, actually. That's actually quite amazing, is we still make lighting fixtures, although LED is the way to go these days. And we're slowly phasing out incandescent light bulbs. They're going to be put in the GE Museum one of these days, and that'll be the end of it. So, you know, innovation is really the lifeblood of this company, and we've always filed patents, and I think this year we're going to file 3,100 patents. And that's the most that I'm aware that we've ever filed. And they're a really critical tool to allow us to take that R&D and translate it into products, into services that we deliver to our customers around the world. There was some discussion about tech transfer and how this debate has gone on since the 1950s. It's unfortunate. In my view, I don't think the debate has progressed very much in these institutions, and I think a lot of it has to do with the fact that there's not a lot of facts to inform the debate. I mean, most discussions, and I used to be a negotiator for the United States in some of these fora, most of these discussions involve referring to previous texts. Well, that's an agreed language in this text, and you sort of parse together something that you kind of persuade everyone else to agree to, but there's not a whole lot of exploration of, well, what are the economics of these proposals? The world has fundamentally changed. The world of innovation and the world of manufacturing has fundamentally changed. Since in the 1950s, it was posited that we needed to have technology transfer from northern countries to southern countries. And I think Pete made a few really good points, as well as the lady from UNCTAD. Technology moves in markets from private enterprise to private enterprise. It doesn't move from government to government by and large. And so some of these treaty provisions that talk about transferring technology from one member to another member of the convention need to be read in the light of experience and reality. And that is, maybe what we should be talking about is putting in place environments that promote the diffusion of technology from private enterprise to private enterprise. And maybe that's going to be part of the key to solving this problem. But anyway, the world really did change since the 50s, and in the 50s we did R&D R&D was done by white men in a laboratory in Niska, New York, and that was it. And they sort of worked in a hermetic environment, and technical information was really hard to share because we didn't really have electronic transmissions or databases or searching capabilities or the internet. But the internet really revolutionized that. There were two things that really revolutionized the way we do business, and I think the way most other companies do business. That was the internet and the TRIPS agreement. The internet allowed for the instantaneous transmission of technical information, of data, anywhere in the world, allowed us to begin deploying R&D labs in a number of different jurisdictions based upon the particular talents of R&D folks in those jurisdictions, but also, probably more important, based upon our need to get closer to our customers in those countries where we didn't really have customers 50 years ago. So, were Brazil and China in India or Africa on our radar screen for our sales forces 50, 60 years ago? Maybe Brazil, China, and India a little bit, but not nearly where they are today. And certainly not Africa, and yet Africa is our fastest growing region in the world right now in terms of sales. So, all of a sudden, the GE leaders took a double take and said, wow, most of our growth is in emerging markets. We better focus on the needs of those customers. And thank goodness the TRIPS agreement was put in place that gave us the confidence not only to sell into these markets, but also to do all the other things that are necessary to engage in technology diffusion or transfer or uptake or whatever you want to call it. So we now have research labs today in China, in India, in Brazil, in Europe, and we have engineering facilities in Africa. I wouldn't call them research labs yet, but there will be a global research facility in Africa in the next 20 years, I predict. Probably the next 10 years, I would say. Because that's the best way to get close to your customers. That's the best way to really understand what their needs are. And it really is the TRIPS agreement that allowed that to happen. It's the knowledge that all of these members of the WTO have bound themselves to a minimum standards agreement, and that they all accept that intellectual property is something that should be put in place for the betterment of technological progress and to help people live better lives. that's a hugely important reassuring factor in terms of our moving into these markets. So, that's been critically important. That's our experience. I think that there's a lot of evidence out there that suggests that IP is a critical, necessary condition, but not sufficient in order for climate change technologies to find their way efficiently to our customers in developing countries or least developed countries. And I think that there's a fairly good body of evidence out there. I guess what worries me about the debate that I've seen unfolding in the last 3 COPs, and this is my 3rd COP, and I have to say it's my 3rd COP. There it is. It's long. These discussions about IP barriers, about exclusions to patentability, about compulsory licensing, these ad hominem attacks on the private enterprises that are oftentimes, investing hard-earned money in innovation, have a truly chilling effect on the desire to continue to invest in this area. I think that it's going to be really important to get some sense of, I guess, a sense of priorities of what's going on in this organization. My understanding when I came to my first COP was that we were trying to create a global price for carbon, and we thought that was a great idea. That would cause, all these wonderful technologies that we've developed to be economically more viable vis-a-vis the older technologies. And I think that Ahmed has made a few good points in the paper. I think that there's clear distinctions between the healthcare sector, the pharma sector, and the clean technology sector. And I think there is some empirical evidence that's been gathered. I think the patent landscaping can be useful, but we have to recognize that this is very limited. All the patent landscapes tell you is who owns what. It's like reading the recorder of deeds for houses in your neighborhood. You know who owns what, but you don't know who's willing to sell what at what price or what they want to do with those rights. Doesn't tell you very much about that. So I think it's wrong to assume that somehow if companies from one country or another country have a lot of patents, that all of a sudden that per se creates a barrier. I don't think that's correct, and I don't think that's an implication that we should make. There's also a lot of talk about licensing surveys and the fact that most companies aren't licensing into LDCs. Well, one, licensing is by far the least common method for technology transfer in any jurisdiction. The most common method is through the sale of the embodiments of the technology. That's how technology generally makes its way around the world, selling stuff that performs in a way that gives the customer the benefit of that technology. So that's like 80%. And then probably 15, the next, except for your company, because I know licensing is your lifeblood at Qualcomm, but there are a lot of different business models around the IP system. I'm talking about the way we operate at GE. The next part is joint ventures. We talked about the Harbin joint venture. That's a really wonderful way to share technology with a local partner and to enjoy mutual benefits, because we bring core technology, expertise, and knowledge to the table, and they understand the market, the customers, and then we're in a better position to tailor that product for that market, and we both win out of the deal. And then finally, licensing is a much smaller percentage, particularly for LDCs, just because it's really hard to find local partners who are capable of implementing the technology merely with a piece of paper, a licensing agreement. And the second point is, in most LDCs, we don't really have any patent rights because our filing strategy is limited to about 5 countries around the world. We file where we do our R&D and manufacturing. We file where our biggest competitors do their R&D and manufacturing, and we file for a couple of huge markets that are critical markets. But if you look at Africa, Africa's a pretty fragmented continent when you talk about different jurisdictions. And so for us to be gathering together patent portfolios for many, many countries in this continent except for maybe South Africa a little bit, but to a very limited amount, it just doesn't make economic sense. Patenting is fabulously expensive. And Jake reminded me, by the way, that IP is truly a back office operation at almost any company, because I'd never heard about this grant until he announced it today. But we get a budget, and then we have to basically figure out what we're going to do with that budget. And so, filing in places in LDCs is not part of the strategy. But I think more importantly, there's this perception that somehow big companies are just sitting here hoarding our technology, and we just cling to it for dear life. And that couldn't be more wrong, because if we don't transfer technology, we're out of business. We are in the technology diffusion transfer business. Our customers need to gain tangible benefits from our goods and services, and that means that if we sell a gas turbine to Nigeria, we come on the ground with the product, we help assemble it, we teach them how to use it, we teach them how to maintain it. They have to derive the benefits from it, because if they don't, they're not going to come back to us. They're going to go to Siemens, or they're going to go to Alstom, or they're going to go to the emerging Chinese manufacturers that are out there that are doing a terrific job with engineering and doing it at a fairly low cost as well. So we need to use our IP in a way that is beneficial to our customers. So I hope that gives you a bit of a slice of life in terms of what the incentive is, what the impulse is within a large company. And then finally, going back to Ahmed's proposal, I mean, it kind of seemed to me that what he proposed is just basically what's going on right now. And that is that the debate ought to continue, that we ought to be nice to each other to talk as we talk about these issues, that there be a structure, and there is a structure to these discussions. Our perception is, frankly, that as an institution, probably it would be better for some of these issues to be left to the expert institutions that are responsible for those treaties, whether it's the TRIPS Council at the WTO, where there are a lot of people who spend a lot of time looking at these issues, and then to use that to inform what's happening in this organization. But we would love to see focus on a positive agenda that relates to creating opportunities, opening up markets, creating a global price for carbon, or if not that, at least creating some best practices about what could happen at the national level, so that clean technologies could have a better chance of making their way to market than some of the less carbon-friendly alternatives that tend to dominate today, because there just aren't the kinds of incentives that are in place to make renewables and more efficient, what we call eco-imagination technologies, necessarily economically viable. But I think that the continued worrying of this discussion on IP is not constructive, and I think it sends a very chilling message to companies that are investing in this area. So I guess I'm going to have a bit at odds with Ahmed on that, although based upon the discussions in the previous panel, I think we agree on many things. But a continued robust discussion on this IP issue here, I'm not sure is something that we're enthusiastic about. So thank you.
Thanks, Thaddeus, and we'll see you in Qatar next year. This is definitely not your last. And in fact, thanks for your presentation. It dovetails very much to the question that I want to pose to Jayashree. What do you think the TRIPS agreement has had on technology transfer and the transfer of environmentally sound technologies in particular? Some people argue that there is a read across between the flexibilities and access to medicines debate. But given the different technologies, I don't think so. But what do you have to say about that?
Thank you very much, Konji. Thank you so much for having me on the panel, and also for the question that you've posed to me. I actually think we need to go back to the proposals on the table in the COP, because there's nobody here who's telling us what those proposals are. We're all trashing them. We're all saying they ought to be thrown into the dustbin, but we're not saying what they are, and we're not saying what was the thinking behind it. There is a presumption that the people who put those proposals really don't know what they're talking about, they have no idea, and there's no basis for what they are saying. That's the impression that we will go away if I don't tell you a little bit more of what's the thinking. So I thought, let me at least try and look at it. And I'm basing myself on a paper that was written by the South Center, which is still in a draft form, and which goes through these issues quite systematically. So the issue started in Bali. And while one of the important concerns was access to affordable technologies, it came from a bigger picture, which was about what's going to happen in 2012. Is the Kyoto Protocol going to continue? Are developing countries going to have to take obligations? If they have to take obligations, should they be at the same level as the developed countries or the Annex 1 parties, as they were called in the Kyoto Protocol, and so on? And this whole philosophy of what is now called climate equity or climate justice, of historic responsibilities, the common and differentiated responsibilities. So the IP debate flows from this bigger picture, which is about climate equity. Let's put it, in this way. I think all of us know what I'm talking about. But it also comes from another mindset, which I would say goes back several decades. And that is about self-reliance, that every country should really produce all essential products and services themselves and shouldn't be really too dependent on the outside world, otherwise there might be a problem, and so on. This debate goes back to the UNCTAD Code of Conduct, which when there was an attempt to negotiate that, there was this mindset that the multinational corporations indulge in anti-competitive practices, and such practices, unless they cannot be curbed by small governments, because their GDP is far lower than the total revenue of some of these companies, and that there is a cost to pay in getting these companies into your markets. This is the mindset. And just to go back to why there is this debate. For instance, I'll just read out just a small excerpt, that in the first phase of technological development, developing countries can go through 3 stages. One is the initiation stage, where technology as capital goods are imported. 2 is the internalization stage, where local firms learn through imitation under a flexible regime of intellectual property. And 3 is the generation stage, where you go to generate your own technologies. And obviously, most countries who are in this debate, who are putting out these proposals, see themselves in the first and second stage. They haven't yet reached the 3rd stage. So in Bali, fresh from victories in the WTO on the access to medicines debate, the foreign minister of Brazil, in particular, Celso Amorim, who was, of course, a key negotiator in the Doha Declaration on the TRIPS Agreement in Public Health, put forward his views that this would be a good thing to do in the context of climate change, because we've just had this victory in the WTO on access to medicines, and it would clear the air in terms of use of TRIPS flexibilities for climate technologies. From that came a number of proposals. There were proposals which brought the G77 and China together. Now, that's not an easy feat, because this is a very disparate group of countries, and including China. So they came to some common ground, and they made certain proposals at Bali. One of which continues to date, and therefore it's important, that is that, in some form or the other, it's obviously not in exactly the same form, but the proposal says all necessary steps shall be immediately taken in all relevant fora to mandatorily exclude from patenting climate-friendly technologies held by the Annex II countries, which can be used to adapt or to mitigate climate change. And the second proposal was about a global technology pool. The Philippines added to this with more specific proposal, but the most extreme of all came from Bolivia. And I'm saying the extreme of all meaning from the point of view of those who believe that such proposals have no part in the climate negotiations. So Bolivia made 6 proposals, one starting from wording taken from the Doha Declaration, that nothing in the Doha Declaration, the wording is nothing in the TRIPS agreement, whereas this has been adapted. So nothing in any international agreement on intellectual property, which includes all the WIPO treaties, shall be interpreted or implemented in a manner that limits or prevents any country from taking any measures to address adaptation or mitigation of climate change. And then it goes on to say mandatorily exclude certain environmentally sound technologies, revoke if you've ever made the mistake of giving such patents, then facilitate technology pools and make sure that they can be accessed on royalty-free terms, and have just ensure that technology is transferred to developing countries. It comes actually from the mindset, which we've been talking about from the first panel onwards, that there is something like technology, which is like a concrete piece, some material or whatever, which can be transplanted just by taking it and putting it somewhere else. So a provision of technology, that kind of thing, that it should be given, it shall be transferred. And that's where it's all coming from. Now, what's the evidence? What's the evidence that they've based themselves on? And I have to admit, part of the evidence at least is something that I've written when I was employed as a consultant to UNCTAD. And this was a study which I did on the Montreal Protocol and on technology transfer in the Montreal Protocol. And that was a very interesting case, because when the Montreal Protocol was accepted in London in 1990, the big issue then, as the issue is today, is you can't leave out such a large part of the world, the population of the world, which is China and India, because they were not party to the treaty. And so they had to be brought in. China and India have to be brought in. We cannot close the hole in the ozone layer without bringing China and India on board. Now, China and India were, along with some other countries, Korea, for example, were producing the ozone-depleting substances, which were the substances which were making that hole in the ozone layer bigger. So they said, we're not coming on board until we get these new technologies, which are non-ozone depleting. And that was the question. So there was language negotiated with the usual Weasley phrases such as appropriate, to the extent possible or practicable, and this kind of language, which really at the end say, well, it's private to private technology transfer, you're not going to be able to get it. But the Montreal Protocol was different in the sense that they had a big multilateral fund. So what happened was I was asked to do this case study at the point where the multilateral fund hadn't actually kicked in, at least in closing down, shutting shop in India of production of ozone-depleting substances. At that point, the companies, and there were 5. Now here it was an interesting case because these were chemicals. The substitute technologies were held by exactly 2 or 3 companies in the world. And I'm not saying this based on my own research. There's a very good book written by the US ambassador who led these negotiations, and that's called Ozone Diplomacy. It's an interesting read for anybody. It's very well written. It reads like a novel, and I think everybody should read it. It's excellent. Benedict, that's the name of the author. He writes this book in which he describes how US was at the lead of this environment negotiation because they had the technologies and they wanted the volumes for their technologies, and they pushed the world to adopt this. Also very good environment reasons, and the Montreal Protocol is a success because we have seen the evidence of this hole now closing. So it has been an environmental success. Now, the companies that I interviewed for my case study told me that they were not able to access these technologies. Not because there were patents in India. At that point, India did not have an obligation to have product patents for chemicals, which was the sector here. But the processes were difficult. They were proprietary technologies in terms of know-how and trade secrets, and they were not able to reverse engineer. They did try, but they weren't able to scale up to, from the lab stage to commercial scale. Korea had exactly the same problem. So another author was commissioned to write another case study for Korea by UNCTAD, and both case studies are published in the same book, edited by Hoffman and Jha. You will find it on the UNCTAD website. And this Korean author came out with the same story, except Korea was at a higher level of technological development. They were able to reverse engineer. They took so long to do it. By the time they were about to get their products onto the market, the market for these products in any case fell because of volumes. Because the volumes were so large that the prices fell and the Koreans couldn't compete with new plants on that kind of technology, on those kind of prices. And so in any case, the solution was lower prices, and that happened. What happened to these Indian companies who were not able to access this? They were all quite happy to take the money from the multilateral fund. They closed shop, and they did other business. Now, that's the story that is cited repeatedly in many forums in the context of climate change, saying this shows intellectual property is a barrier to technology transfer. There are many important differences. Number one, these were chemicals. And chemicals, the whole model, business model, is very different from all the variety of technologies that we talk about in climate change. So intellectual property, and particularly patents and trade secrets, are extremely important in the case of chemical technologies. Number one. If they could have reverse engineered, they could have used compulsory licensing if there was a patent in today's world, in a TRIPS world, you could have used compulsory licensing if you could reverse engineer. But the point is that these very, very specific case studies don't show anything other than what we already know in the context of standards, for instance. That where you have patents, you must declare them, and you must then say that you're going to be able to license it on fair, reasonable, non-discriminatory terms, because there's a trade-off. You're getting volumes, and for the volumes that you're getting, that is your sales revenues, you're able to take some reasonable royalties. Now, I know from discussions with those who've done much more work on this that it's not always easy, even in the standards area, and that's very, very interesting and very revealing. But the Montreal Protocol was somewhat like the standards case, which is not the case in climate change. And so all these proposals, they come with some evidence. The second evidence that is cited in these kind of studies which have been done and cited even by delegates and so on is the case of China, where they say the Chinese are not able to get the latest cutting-edge technologies. And you have to ask the Chinese, if they had the latest cutting-edge technologies, would they give it away to their competitors for free, or even give it away in any case? So the business model is the same for anybody. It doesn't matter who has these technologies, and the world is changing rapidly. So these things are going to go either way. So we have to think carefully about what we need. But I'll close with what I said earlier, in an earlier side event, that really, the middle ground, what are we talking about middle ground? The middle ground is already there. The TRIPS agreement is the middle ground. That was negotiated. And you have the rights, you have the flexibilities, and it's already there. Nothing that you say here is going to change any of that. So why not just accept that and move on from this issue at least? Thank you.
Well, ladies and gentlemen, That was quite an interesting panel, I think, and I expect to see 10 hands up. We have 30 minutes. Pete, I can see you dying to ask a question. Yes, sir. Oh, sorry. It's the light in my eyes.
Well, I just have a comment on the last presentation. I've read some of the studies about the ozone chemicals and also the HIV drugs. And what's unique about those situations is there are a small number of manufacturers, a comparatively small number of patents. So the targets for negotiation are more easily identified, and more likely you can bring pressure on them to reach a solution, aside from the market incentives that you just mentioned. I'm aware of patents in the energy field. For example, IBM, for example, may have patents on circuitry that can control the power grid. The same circuitry could be applied to telecommunication networks. So if you prevent, and the patent is written as the circuit, it's the application. So in one case, if you were going to exempt them for energy technologies, you'd be talking about the same patent in one application being exempted, or if I understood your earlier, the earlier proposal from the negotiations, you would in fact prevent them from obtaining it in the first place. So we have a situation here where it's thousands of companies and hundreds of thousands of patents, and there's a lot of analysis to go through to implement some of the proposals from the early days of this discussion.
Yes, Marcus Gehring from CSTL. I really liked all the presentations, but I wanted to press Ahmed a little bit on his methodology, because Ahmed, you suggested that IP rights couldn't be seen as a hindrance to technology transfer because in many areas there weren't a lot of patents in developing or least developed countries. But as we've heard from the Council from GE, what particularly large companies are doing is they're not even selling the technology to these countries, regardless whether there's patent protection or no patent protection, because the general governance system, the rule of law in those countries is relatively weak, and therefore large companies have no confidence in them. So I was wondering whether you're planning to inject a kind of variable into your analysis that actually shows or draws a link between the amount of patents and how much technology is actually sold to these countries.
Take a few others before we respond. Thanks.
Thank you very much. I'm Tom Brewer. I'm a Schiller Foundation Research Fellow in Germany. My question is about how to get out of the impasse. And abstractly, at least, I could imagine two different approaches. And my question is going to be whether either or both of these is feasible, practical, imaginable, or worth trying. One is to link these issues to other issues, and there are, of course, many other issues, and to develop a package of agreements that could include financing and a variety of other issues that are on the table here in the FCCC. The second approach is to sort of get away from the country focus and move toward a sector focus, an industry focus, and maybe there are other venues. I mean, I could think of some in some industries. I wouldn't necessarily recommend them, but in aviation, in maritime shipping, obviously those are in a sort of a different situation. So the question is, are there ways to link these issues to other issues and resolve at least the impasse? and/or are there ways to shift the negotiations into sector-specific arenas?
Thank you. Pierre Deploy. I just wanted to ask a very sort of practical question around, because this audience seems to be in agreement with almost every panel we've had. There's no argument being had here. How do we, and this is not so much technology dissemination as information dissemination, are we getting this information out to the people in the ICC, specifically, I think, the developing country members? And is there a way, maybe I'm just not following where that happens, but to lay many of these issues to bed by inviting all of the chief negotiators to some exotic island resort, along with us here, of course, and to have that exchange on a very much on a expert to negotiator platform, so that a lot of this information, that this is an unusual amount of consensus, it seems to me, that this consensus can be shared, and invite by all means some of the dissenting parties or experts on the other side of the fence. I don't know who those might be, but to almost put this issue to bed in a way, in a very practical way, but specifically so that we don't just talk amongst ourselves, but get to the negotiators.
I think I'll ask the panel to respond. If you can take a pause on questions then.
Thank you. Marcus, I'm not sure if I got correctly your question, but what we're trying to say is that because in low-income countries, there are almost no patents on many of the clean energy, at least mitigation technologies, right? This is what we know from the evidence. Proposals to exclude climate technologies from patent protection in these countries don't make sense, right? So we should put them aside for the moment. So that's what we were trying to say in that regard. Maybe so I think that's your questions on linking to other issues. I think it is a valid point. There have been proposals to link the way you address or could possibly address IP issues to the financing, right? And that the Green Climate Fund would have maybe a window on relating to assume some of the possibly licensing cost, or if you're facing prohibitive licensing cost, etc. That is an issue that is raised, and it's an interesting proposal. Again, I think it merits discussion. And maybe the sector focus is also an interesting one, because we know quite little still about, for example, in agriculture, patenting of seeds, etc. There's still not much information about that, and again, it's a sector that could require closer examination in the next 10, 20 years. I mean, because a lot is going on there. So yeah, I think that the sector is also, and I would say more than sectors, the case by case actually, to move a bit closer, but definitely that is that has a lot of value. On the negotiators, I think you're totally right, and we try maybe to reach out on an individual basis to negotiators, but I think that the kind of exchange you're suggesting, but just take into consideration that these negotiations are facing so many other issues, right? And so many other issues are unsettled in the bigger picture, that by the time you get to this issue, there's not a lot of vitality left. But I think the more we settle the bigger issue, the more we're gonna get to this thing.
Anyone else?
Yeah. I'll just take up one of the points, following up from what Ahmed said, on the different approaches. And the more I think about it, and the more I talk to people who are, who have taken this point of view that IP should be part of the text and so on, I feel it could be a negotiating tactic to get finance and to get other things onto the table. So the package is what is going to sell in the end. And so whether IP remains or comes back or whatever is going to depend on the satisfaction people have on the entire package. And I think that's a fact. So I don't think, it's so much a question of education, because I can't believe people really don't know what they're talking about. I mean, to this extent, I think there's been quite a lot of information dissemination. Even on the WTO website, you can go and see that there are no grounds restricting you from compulsory licensing, this kind of thing. So I don't think it's lack of knowledge or information dissemination. It's more because they're not satisfied with the entire package.
I'm going to be unfair to my colleague Joe Bradley and pounce on him because Joe participates in a lot of intra-COPs and pre-COPs. There's Bonds and there's Bangladesh and there's Bangkoks and there's stuff happening in Panama. And to Pete's point, actually, that would be a forum before the COPs where, we don't speak to the converted. This group that has consensus should be in the room speaking with those who will then be in the closed doors, but carrying forward that there are no issues. There are no issues in the issues that they're discussing. Is there room, or does that happen in these pre- and intra-COPs?
Thank you, and thank you, Konji. Thank you, Konji. The extent to which these issues are discussed outside the COP and the extent to which there is information and knowledge amongst the negotiators and amongst those participating on IP, I think is varied. I think it's as Jashri says, there are a lot of people participating in this who know exactly the issues. And obviously there's a political element and dimension to the negotiations as well. But also there are a lot of people participating in the technology side of things who don't know how the intellectual property system works, who don't know the disclosure function and other aspects of it. So a large part of our effort at WIPO is to try and close that gap in terms of knowledge. So we participate in the intersessional meetings, we participate in the Technology Executive Committee's first meeting, and we try and share as much information as possible with negotiators and with those participating on the intellectual property system and how it works, to try and make sure that the negotiators and those involved do know what can be done and what can't be done. So I think a lot of the points Jashri makes are very, very valid. It's a mixture. But certainly there's enough knowledge there for those who are at the heart of the negotiation.
Terius, do you want to say something before you leave?
Absolutely. Pete, the lack of IP in any country never prevented us from selling something to a customer. So that's, obviously a lack of robust IP protection might cause us to think twice about putting an R&D facility there or setting up a manufacturing plant. But when it comes to the overarching purpose of our business, it's to get the technology in the hands of the customer and make sure they enjoy the benefits of it and that they want to come back again. And so I think that's an important point about where IP fits in. And then I think Jayashri made a really great point. Everybody who's discussing these issues knows the TRIPS agreement well. I think where there's a lack of experience and perhaps shame on us for not being more, for not reaching out more, for not helping people understand better the world of commerce, is that I think a lot of negotiators don't really know much about the world of commerce and how IP interfaces with the world of commerce, and how the way these agreements work themselves out in the granular day-to-day decisions about whether I license, whether I don't license. I mean, I'm going to give you an example. A really key important factor when a business leader decides to say yes or no to a license is, well, if I don't license, will I meet my quarterly earnings target? And if I do license, maybe I'll meet the quarterly earnings target. You know, granting that license is going to have an effect on his business probably for a number of years. But the most important thing to survive in today's business environment is you better meet your quarterly earnings. That's so important. Survive today and hope to continue on. And so that's just I think hopefully that puts this in a perspective, and maybe we as business need to be doing a better job to sort of elaborate that commercial environment that really informs what this language means. And so you have TRIPS, then you have your national legislation. There's sort of a cascading effect here. Thanks.
Yes, Jane.
I mean, in terms of other venues, I wanted to sort of contrast this with my recent experience at APEC, which the United States hosted this year. I just a couple of weeks ago came from Hawaii, and I've had a wonderful travel schedule over the past couple of weeks. I think, you know, if you compare APEC and this process here, the UNFCCC is particularly ill-suited to do some of the educational activities that Thaddeus and Joe were talking about. You look at it here, there's sort of an isolation between the private sector and the negotiators who are doing the important work of the negotiations, but who don't really leave time, at least not on a scheduled basis, for interactions with groups like us who could provide, I think, some information. You know, we went to APEC this year, and we were in Big Sky, Montana in May. It was the second senior officials meeting. And the U.S. Trade Representative invited me over to go do a presentation on technology dissemination, actually, only because GE couldn't attend, and so I was the second choice. But so I did a presentation on that, and you know, you go through, and I gave a similar talk there about, you know, how I didn't like the word dissemination. I thought attraction and deployment was a better way to look at it. And you know, 10 minutes later, everyone in the room was talking about attraction and deployment and not dissemination, and it was wonderful. And I think there's an opportunity to do some of that education, possibly in the UNFCCC as well. And you know, one of the hopes that we have is that the technology forum, the mechanism, and the center and the executive committee could be an entree for more collaboration and better educational efforts between the private sector and the government. And I mean, because APEC actually had a very successful outcome, and one of their large focuses was on green growth, I wanted to flag one outcome from APEC, which is that countries agreed to a tariff cap of no more than 5% on a list to be determined of environmentally friendly goods and goods. That's really important for us, and I think, you know, much in the same way that APEC had a useful effect in bringing forward the information technology agreement more than a decade ago, it could have a similar effect with an environmental goods and services agreement. And so that's the thing that you know, gets our guys excited, for certainly. So.
Thanks, Jake. Another round of questions, please.
So the question straight back to General Electric, why are you not selling these wind technologies to least developed countries? Why is, you know, you're describing Africa as a growing market, but most of your sales are in, you know, in countries that are almost approaching middle income countries?
Well, I wouldn't say that we don't sell to least developed countries, and I actually have a matrix of our technology transfer activities that includes a number of African countries. So I'm happy to, if you give me your email, I'd be happy to send that to you. But you know, China's a pretty big economy, and nobody stands up to China when it comes to volume. And so it's just the reality. And they have $2 trillion in foreign reserves to spend. And that's, you know, that's a lot of foreign exchange. I think that one of the really important aspects of this process is going to be the creation of these regional technology clusters or centers that will, on a regional basis, in continents like Africa, start creating supermarkets that would be larger than a single nation state, that could all of a sudden begin to create scale in terms of how do we scope a market, how do we understand a market's needs, and to create some of the infrastructure that's necessary, some of the tariff reduction, for example, that's necessary in order for these technologies to be successfully deployed in small and least developing countries. And I think that's really one of the very positive threads of discussion that's been going on in these negotiations that we pay a lot of attention to. I think that, for example, countries like the United States and the European Union need to do a much better job with their export banks to help with financing with these kinds of projects. And we're working on the ground in the United States and in Europe to make sure that financing becomes available both on a bilateral but also on a multilateral basis.
Yeah, Jake's comment a few minutes ago about the tariff negotiations at this recent meeting triggered a thought, and I don't want to speak out of turn. I think this is an ICTSD study, I read this in, that some of the countries that are complaining about intellectual property rights being a barrier actually have tariffs on clean technology. For example, China has some huge tariff, or at least they did, on clean coal technology. So as an example, an average patent royalty rate tends to be something 3 to 5%. And this was well in excess of 10%. In fact, it may have been 20, 30, 40%. Just wanted to throw that out as part of this debate.
Well, we think that is a legitimate barrier to the dissemination of clean technologies. I mean, if you have an 18% tariff on wind turbines, that's a barrier.
I think that's absolutely right. If there's the real barriers with respect to the dissemination of these technologies relate to tariffs and non-tariff barriers, for example, local content requirements that often really make it impossible for a country to become part of a global supply chain. All of these technologies require tremendous scale in order to be economically viable. So you cannot build combined cycle gas turbine plants in every country in which they're to be sold. It's just so expensive and so large. You need to build scale. In order to do that, there have to be fairly open markets. So that's some low-hanging fruit, in my view, if we want to talk about dealing with barriers to technology dissemination.
Well, I would just to build on that, maybe I'll just flag one more barrier that we see and that we've been working on recently, which is data flows. And we've been working with our members, including GE and Google, Microsoft, and a number of financial services companies. What we see is, as Thaddeus mentioned, the internet is tremendously important to companies of all shapes and sizes who do business in the world. There are, I don't think that trade rules have kept up with the internet and with the amount of data that whizzes around the world these days. Whether it's rules governing privacy in different regimes between, say, the United States and the European Union, security issues, sort of forced localization requirements that prevent companies from scaling up, whether you're talking about clean technologies or financial services. But beyond that, I think it will be important to make sure that trade rules are sufficient to create an environment that allows information to go around the world and for companies and countries to collaborate. If you're talking about developing and standing up these regional technology centers, it'll be important to get the rules right governing information so that if you're in one place and you're trying to transfer information to another place or collaborate on a project, you can do so without worrying about conflicting jurisdiction or privacy rules or export controls that are going to limit your ability or add an additional risk to that collaboration. So.
I think on that note, we seem to have exhausted all questions we have or anything pending. As Piet said, it's the converted talking to the converted here, so we should have brought in some serious activists here to counter everything we've said. So it's been all happy and honky-dory. So I guess on that note, we shall go find some activists somewhere and get some excitement for the day. Thank you very much for being here. Thanks to the panel, and thanks everybody. Thank you. Have a good day.